handovers, are we saying external?
I'm actually going to ask a question that I think might link.
Because I'm not forgetting the internal here.
My question is actually specifically about recruitment. And a lot of companies, because of the way the market is at the moment, a lot of companies actually have internal recruiters that are out there trying to attract passive candidates. Mm-hmm. So actually recruitment in a lot of contexts is working very much like a marketeer.
Yeah.
Going out there and trying to get hold of people. So it's an internal HR type function operating like a marketer to try and get those candidates in. How much change will GDPR impact that kind of activity? So if I'm a candidate, someone talks to me, will I have to sign something that says that yes, I consent to talk to you?
So you've got two situations actually. You've got that, and you've got the headhunt as well, which is an externalisation of the same concept to some extent, because they may too be looking for
their business.
Well, yeah, but we've got two to think of. Can I hear your question as well? Because I'm feeling, and then we'll see the order in which we take these, because I'm feeling a bit unfair at the minute.
Back to talking about your privacy notices. If you're reviewing your privacy notices and reissuing them to your existing employees,
yeah,
would it stand you in good stead in case the ICO ever did come in to be able to prove that your employees have reread those privacy notices? So would it be an idea to get the employees to in some way indicate, not only have you put this on our intranet, but I've read it?
Yes.
It would certainly stand in good stead, yes.
Okay.
So
because it's back to this accountability. You know, you're saying you've taken all the steps you could to get accountability.
And how do we do that?
Well, effectively, you get them to sign to say they've received it. You get an acknowledgement. You use a DocuSign type system, which some people might use when they've received it. So there's things like that you can do, and then you capture that consent.
In our HR system, we've got the ability to publish things on the HR self-service and to make it a mandatory read, and they have to tick a box on the screen. Is that sufficient? It doesn't need to be.
Yep, that will give a record to say they've read that privacy notice. Whether they did or not, you can't tell, but they'll tick to say they've read that privacy notice.
And then,
that
which is certainly the way we internally would do it. We operate a system that we provide to a range of clients an HR information system, and actually one of the tricks with that is you make sure that when people want to book their holidays, they have to go into the system to book their holidays, and they have to go past a screen which effectively includes policy changes and notice changes, and they're going to have to tick to say they've read those in order to move on to the screen to book the holiday. So that's part of the deliberate structure.
The internal, external, although internally you can't get the consent, the sheer fact that you're acknowledging they've done those privacy notices, you're ticking that box and recording, that's what we like to call it, consent internally.
Yeah, that's great. So that's the way in which you're looking at consent internally. Should we go back to that point on recruitment now? So we've got
it's a massive point. It's a massive point. You split your thinking between proactive and passive. So if you're proactive, you're a recruiter, you've got a list of names and you want to email people or contact people around the off chance.
Many more
you're going to need consent. What I watched over the weekend a couple of really beautifully presented webinars from recruiters, and it was all very posh and swanky, but when they were talking about receiving CVs in, they were talking about needing consent. So which is, to be honest, it's just not right, because we go back to this processing conditions point, and one of the processing conditions is you can do it for the performance of a contract or quotes in order to take steps at the request of the data subject prior to entering into a contract. So when you hear recruiters talking about needing consents around when CVs come in, rubbish. If you're doing something at the request of the candidate, no problem. If you're going after the candidate, problem. You need consent.
Or all of these CV databases where you put your
all of that. All of that,
ago.
you need consent.
Yeah.
So we strip that down. CV databases, you're looking for the consent of the person to go onto the CV database to have their data held in the first place. Yeah? As that's what it's saying. But the passive... Go on.
Not necessarily.
Okay.
If your privacy notice is very clear, for example, that when they send you the CV, you're going to keep it for 6 months unless they tell you different, no problem. So what you would do is make sure at the very least you send them an email with a clear and obvious link to your privacy notice.
So that's your upload obligations. If someone's going to upload the CV, you're saying on there, if you're going to upload this, the basis on which we accept CVs is the following basis. If you don't want to upload it, yeah, okay. So we're comfortable with that, but it's worth noting that needs amending. So, and we've covered off the one of those scenarios you've talked about.
The law around the practicalities of that isn't changing much, because I come back to this point. This isn't the start of data protection laws. Data protection laws exist significantly now. So you bring it back to the data protection principles, and what's the relevant principle there? The last one, integrity and confidentiality. So what you'll be expected to do, as you're expected to do now actually, is verbally give an appropriate privacy notice around what you do with certain information. And in terms of securing that personal data that you record, you're supposed to take appropriate measures, bearing in mind the sensitivity of it in a non-technical sense. It's, you know, if that goes missing somewhere or gets hacked, there's big trouble. So the position is really as it is now, in the sense that you still have to take appropriate measures to secure that information that comes in verbally over the telephone system.
So I know some organisations will actually pause recording for the purposes of that credit card information passing. So there are different approaches. So you're being asked to look at a practical solution for doing that. I'd like to get on to subject access requests. How exciting. Now, as you said, in the past, maybe 7 or 8 out of 10 people saying that, asking for subject access request, everyone understands what subject access request is. So somebody wanting to know the data that you hold on them. In the past, you write to them and say, show me your 10 quid and I'll do it. And in practice, you found sort of 7 or 8 out of 10 never got round to sending the £10 cheque. Probably because they didn't have a chequebook anymore in most cases. And so it died a death. So first question now, I think you said it doesn't have to be in writing.
Correct.
Okay, so somebody says to you, I bet you, I bet you've said X, Y, and Z about me, and I bet if we had a look at all the emails floating around, it would be interesting to know what you held about me. It really would, and that's the email you get, or that's the phone call. If that's the conversation you have with them, what is that?
There's going to be an element of interpretation. If those are the words used and they're just saying it'd be interesting to know, I don't see that as a request for their personal data.
Okay, I want to know.
In that case, it's a request. It's a subject access request. It'll be so if they're saying, I want to know what personal data you hold about me. The likelihood is, as you can now, you can ask questions with a view to limiting the nature of the personal data that they're most concerned about, and you'll be expected to be. But if ultimately they say, I want to know all of the personal data you've got, that includes opinions about that person in emails. So that feeds into understanding, if you're on a data mapping basis, where all this stuff is likely to be. And it feeds into having protocols in place to understand what searches and search strings you're going to run to find the relevant information. Because if you haven't thought about these details beforehand, where do you start? It's a big job. So it's going to be really important for people to have protocols in place and to train their staff in terms of A, spotting a subject access request in the first place, and B, how you go about actually responding to it.
So do you think it's going to be a big issue?
I think it's going to be, on the again, split thinking between internal and external. On the internal side, when you're dealing with employees, I think it's a massive issue. Absolutely enormous, because at the moment, employees who are so minded can effectively troll you by making you go through a massive paper trace to find this stuff. In future, it's going to be much easier, and at the end of that process, they can pull out the phone out of their pocket, issue an employment tribunal claim, no fee, job done. So the risk landscape for employers in terms of both data subject access and then where that leads, the risk landscape is, I really can't put into words how much things are going to change in that regard. We're going to see so much so that I think some HR departments we're going to have to resource up to cope with it.
So the last few years have been very, very different, haven't they? So tribunal fees came, tribunal claims fell to between a third and a quarter of what they were, and most of those were public sector group actions anyway, so basically there weren't any claims. And so you foresee quite a different future.
Hugely different future, and I think, I mean, we're seeing now, we're having more tribunal claims over the last few months, and that will only continue.
And you think SARS are going to feed that?
Hugely.
And I think this boils back into what we were saying effectively about the importance of doing your audits and your data mapping and knowing your data, your retention policy, and deleting old stuff when it's not needed. And it leads on to the fact that managers retaining data, and we're always advocates of good practice, and therefore it's got to be fact-based. Stop doing opinions or notes or things like that about managers. And this is the good practice you should be encouraging, because there is a risk there. Because when that SAR comes in and you then start to trawl all these locations with all this data, then there's a big risk. But if you've got in place clear accountability, processes, systems that are managing your data for you on an ongoing basis, then it will become a lot easier to respond, hopefully with the right answers.
External picture, do you see a big change there?
It has. I don't think it'll be a big change. I mean, my view is that when we talk to clients anyway, naturally we say, be careful what you say. Don't put it into the system. Don't add your comments about this bloke's a whatever, whatever. Because obviously at some stage they could ask for the record.
Mm-hmm.
I think from a business perspective, I don't think it'll be. I think we're the same personally. I don't think suddenly people are going to sit up and go, okay, send me everything you've got on your system. From business.
Okay.
And it leads on to the right to be forgotten and erasure and all those sort of things which we haven't touched on much. That effectively, when people are requesting this, you have to weigh up and say, well, this is what it boils down to. Do I need this data? And if I need it, then that's fine. If I don't need it, what am I doing storing this information? That's how it works.
Just a very quick question on the same thing, especially from the point of view of an employee, and this isn't even from my business, I'm just thinking of me as an employee, many years ago. How far back does it go? I mean, I can think of an incident when I went to personnel department in the 1990s, and I'm just thinking, so actually if I,
Well, it's a good question. The first point I would make is that any employer that has been complying with data protection throughout will have a retention policy, so a lot of this stuff should have been deleted. Most don't have retention policies, and this is exactly the point Kev made, that it's going to become really important to have retention policies that people actually use, because the more stuff you keep that you don't really need, the more stuff you've got to trawl through.
And the days are gone of opening filing cabinets and pulling out P files with CVs going back from when they joined the organisation 20 years ago. You shouldn't be storing it, and this is why the data mapping is important, because you should be looking at to say, well, why have I got this data?
Yeah.
If it's no longer relevant, if they've changed the address, if they've changed the things, it should be removed, deleted. There's obviously some legal requirements why you keep certain data, such as the 6 years minimum or whatever for background checks and things like that. So there might be retention, which is what should be covered in your retention policy. So we retain your data for 6 years because we have a legal obligation to do that if we're doing background checks or DBS or something like that. So there's things like that where you have to retain. But the other data, why are you keeping it?
I've got bank account details of somebody, we gave him a refund.
So my question is, why are you retaining that data?
Yeah. I'm going to take one quick last question there.
I just wanted to check, as far as the subject bits are concerned, the actual search criteria, has that changed? Because there's always been it has to be a searchable process and system, and there were some limitations on.
There are some exemptions. The search criteria hasn't changed. Your starting point is if it's personal data, it needs to be disclosed. But there are some exemptions. For example, if disclosing personal data would prejudice negotiations that you're involved in with, say, an employee, that doesn't have to be disclosed. Or if you're planning a redundancy consultation process and it hasn't been announced to the staff yet, and that would prejudice management processing, that doesn't have to be disclosed. Legal professional privilege, conversations with your lawyers don't have to be disclosed. But no, Robert, the fundamentals that personal data needs to be disclosed and all personal data hasn't changed.
I think the difficulty is now technology has moved on, you know, since the DPA came in initially, and now of course, you know, what is a relevant filing system? The sheer fact you store it somewhere, even if you scan it in somewhere, it becomes part of a relevant. Again, the days have gone where you opened a drawer and there was just a whole random bit of paper in there. Even that would now class as a filing system. So you everything.